And I've been part of the fidelity and surety industry. This industry that I told you about before, with the miscellaneous bonds and the commercial bonds and the construction bonds and the court bonds, supersedious bonds, probate bonds, all that stuff for years. And I've dealt with these people. I've spoken with them. I know what they're like. I've been involved in litigation with them. And they don't know much about you at all. And so what Jerry and I set out to do was to teach them about you, because they're valuable allies to have. They're valuable allies for our industry to have. And it's important that they understand what you do. I am a fan of your industry. I believe in your industry. I think you provide value. I think you're critical to our system. And I need to get that message across to the other folks that they understand their industry. And I can't explain their industry to you quickly. But what we needed to do is to find a way to get the message across to them. So we had a wonderful opportunity. This opportunity came up when Jerry and I were asked to author a chapter on bail in a book called The Law of Surety and Commercial Surety and Miscellaneous Bonds. This is the book. In this book, it's a large book. It is a comprehensive book that provides detail. Provides detail not only on bail bonds, but it provides detail on all of these other types of commercial bonds that I've been telling you about. Not necessarily construction bonds. That's another 6 volumes, okay? But commercial bonds, that's what this is all about, and it goes through all of them. And so what we've got, and I think they either will be or will be distributed somehow here, we've actually got the chapter 8 from this book, which is the chapter we authored, in which we explain bail to the larger world of suretyship that we see in New York every year, and in this case, this was presented at Hilton Head, North Carolina.
I'll put that up on the website, the PBUS website.
Right. I want it to be available to you because you're going to be trying to explain bail to others, and I want to give you an authoritative piece from the American Bar Association that says what we do. And I'll add one other thing. This publication doesn't just say, here's what bail is all about, here's how it works. It talks about the value of bail. It talks about why bail is better than all of these other types of pretrial release that we've heard discussed today. It was interesting presenting this to the larger community of surety. Over the years, my fellow attorneys in the ABA have, they know I've been involved in bail. They know I've been doing it for a long time. And they all think it's rather exotic. They think it's kind of strange, kind of, wow, that's interesting. But it just didn't make sense to them. Okay? It was just an odd thing going on. They didn't quite understand how it all fitted. They knew it made a lot of money. I mean, they knew it was a profitable business, but it just didn't make sense. So I actually gave the paper, presented the paper to the ABA at Hilton Head last year. And Scott, interestingly enough, I went there and I was going to give my presentation, and I saw Georgia Bail Agents Association at the room right next to it. And I went in there and I met Scott, which is essentially how I got the invitation to come here. It was really interesting. We were presenting this national paper at the same time the Georgia agents were meeting. Very, very interesting. Well, the reaction to that conference was really wonderful. A lot of the attorneys and company executives throughout the country came up to me and they said, wow, I think that's the first time we've ever understood what these guys do. I I never understood it before. And it's really important for you to know that there really are some interesting common underpinnings between what you do, your form of suretyship, and the suretyship that the rest of the world does, actually. And the most common underpinning is the fact that what you issue is a tripartite agreement. This tripartite agreement means a three-party agreement, which means obviously there's a principal. In your case, it's the defendant's got to show up in court, the obligee, which in fact is the court, and then the surety. Now, I understand that there are cash agents in the audience, and I understand that there are surety agents in the audience, and I understand some have insurance companies involved and some don't. But you need to understand that whether that's the case or not, you're part of the insurance industry. You're part of the surety industry, and what you do is part of the larger industry. These people have to be our allies. They're important to us. They speak for us, and they speak for us in an American Bar Association that has other arms of it that speak against us. So it's important that we build allies, and that's what this is all about. We are building allies, and we're building bridges with policymakers. That's what's so important for you to understand. For you to understand how confusing you are to these other people, why it's such a mystery, and why it'll be such a mystery for you to explain yourselves to others. First thing I talk about is, I want to talk about why bail's so different from these other forms. Now, I got to tell you, the condition of a bail bond, which is that the defendant will appear in court as ordered, are really different than anything else seen in the rest of the surety world. In the rest of the surety world, what you've got is indemnity bonds, okay? Not penal bonds. That's the big distinction. Bail has penal bonds. The others have indemnity bonds, and when I'm using the term indemnity, I'm not using it the way you normally use it when you say that you're going out and getting an indemnity agreement. I'm using indemnity to mean that the bond is there to indemnify the obligee of the bond, the purchaser of the bond, the person to whose benefit the bond runs. It's going to indemnify that person and make them whole. So the rest of the surety world, everybody out there, everybody dealing with every kind of surety bond in this book, what they're really talking about is making the obligee whole, indemnifying them. So for example, if there's a $1 million construction bond and the contractor leaves the garage door off it, okay, the surety must indemnify the owner for the cost of the garage door. But the bond penalty of $1 million doesn't need to be paid. It's not a penal bond. I gotta tell you, the penal bond is a scary thing to the rest of the people in the room in Hilton. Wow, that was amazing. They couldn't believe that one. There are also some common underpinnings beyond the mere obligee and principal and surety. And I just want to mention a few of these things. For example, every single one of these bonds, including a bail bond, is going to have tailored bond conditions. They're tailored specifically to the needs of the bond obligee. The court needs to get the defendant there, okay? All of these other bonds are tailored to specific needs of specific industries, of specific situations, and specific contracts. Every single one of them, every single one of these bonds assures that a principal is going to perform. That's what it's going to assure. In every single one of these other bonds, there is a long history of legal precedent. And there's also a long history of expectation that the obligees and the purchasers of these bonds have. Okay? All of these bonds involve experienced underwriting. Certainly yours do. All of them use third-party guarantors, indemnitors. They all use that, every single one of these bonds. They all use indemnity agreements and collateral. They all use penal sums. They all involve claims handling and adjustment. And they all, unfortunately, involve state insurance department regulation, okay? Which I am very familiar with coming from Colorado, where it has been a sport. There's another commonality that's kind of interesting too, that I've noticed that most people haven't, because I've seen it in both industries, is that the term power of attorney in the rest of the surety world is, there's a power in the rest of the surety world that goes to the agent that could write the bond, or the bond producer, and his name is printed on them, and it's not fungible. Only that person can use it. When I explain to these people that your powers of attorney can be used by anyone who is qualified as an agent to write, there's like a gasp in the room. What is that like? I mention that to you because I want you to understand there are little differences that others don't really understand. It's important that you get that. But the differences are very important. Bail's primary purpose is particularly critical. As we've talked about, the idea of all other bonds is to make the obligee whole. But as Jerry and I spent a lot of time trying to explain in this chapter, bail bonds are only intended to get the defendant to court. That's the sole purpose. Compensation to the court system plays no part in the equation whatsoever. But what is clear, and what I tried to make clear to the people at Hilton, is that our agents, our industry pays its claims. They honor their obligations. They honor their obligations to the court system, and unlike other forms of pretrial release, we meet our professional obligations. We know what they are, and we do the right thing by the court system. They can count on us. And I tried to get that message across, and I think we did. Another very strange component that they didn't understand in Hilton, and that the rest of the industry didn't understand, was the critical importance of the bail agent. It's really, I'll explain it in a minute, but you guys are different than anything else in the surety world. And I'll take that on in pretty much in the next slide. But the other thing that is a major difference is that your industry is concerned about public safety. Public safety is critical to what you do. It's critical to the court system. It's critical to the public. And you guys take care of that. You're involved in public safety. No other form of surety, no other form, miscellaneous or otherwise, is involved at all in that dynamic. Now this slide here really basically simply talks about who the parties are, and I'm going to kind of jump over it, as well as the next slide. What I want to get to here is why you're so different and why you're so important. Okay. The very substantial difference that we had to get across to the folks at Hilton Head was that the bail agent receives the vast majority of the premium, the lion's share of the premium. That is simply not understood. They don't get it. They don't see how that works. They also don't understand that the bail agent actually earns that premium by doing the bulk of the work and taking the bulk of the risk. They didn't get that. That was an astonishing concept. But it's something that you have to be aware of when you're talking to other people in the industry and other people in the insurance industry and other people whom you hope to bring in as allies in what you intend to do. you need to understand that you are different than they are, that bail agents are different, but they achieve the same result. Because of the fact that you guys take a much larger role, when I mentioned something like the buff account to the folks at Hilton Head, I had no idea what I was talking about. Absolutely no idea. It was absolutely unheard of. When commercial surety bond producers in all of these other industries take collateral, for example, they turn it all over to the insurance company. Why? Because they're not themselves liable for anything. They only take a small part of the premium, and they have no liability whatsoever. Unlike other agents, you play a major part in underwriting. They don't. They present it to the insurance company for underwriting. You do that underwriting. The other thing about it is adjustment. You do the adjustment. You actually adjust these claims. In the rest of the surety world, they do anything they can to keep the agent out of adjustment. They want them as far away as they possibly can get them because they have their own claim departments to handle that issue. And if an agent gets involved in it, the only thing it does is essentially screw things up. I just want to tell you that we had a very positive and very encouraging reception at Hilton Head by the rest of the industry. As Jerry would probably say, we're hoping that bail is not treated as that red-headed stepchild of the surety industry anymore. The commercial bail industry is highly successful. It's worthy of the utmost respect. And hopefully our chapter will foster that understanding. And we're also hoping that this chapter and this explanation of bail to the rest of the world and to legislators and to the public will give you the tool that will allow you to explain our world and the legal terms of our world to the businesses and to the policymakers who now believe that the ABA speaks with one voice when it doesn't. You have supporters now. I can tell you that I was very honored to have been invited here today to basically explain where you fit in, that there's a much larger world that you fit into. And I think what we're trying to do is to build understanding in that world and build alliances, and I think we're getting a long way to do that. Jerry's now going to present to you the rest of the story, and I will turn it over to him. Thank you.